Hello, good morning students. Please subscribe the channel, drop a like, share and comment. This is Shree Vishnu Art Press Publications, exercise number 11 and 12 on the speed of 90 words per minute. Start. From a perusal of the inspection report dated 12/2/2004, it is clear that there is no finding recorded by the sub-registrar to the effect that the building was in existence prior to the date of the sale deed. On the contrary, the petitioner has taken a specific case before the authorities below that the construction was made after the sale deed was executed. In support thereof, the petitioner had submitted the plan of the architect prepared after the sale deed and also produced her bank passbook to show that withdrawal to the extent of about rupees 4 lakhs had been made by her after the sale deed had been executed, which amount was utilized for the construction on the plot. She also filed her affidavit as well as that of the contractor in support of her case that the constructions were made after the sale deed was executed. However, the authorities below have relied on the report of the sub-registrar and held that there was deficiency in payment of stamp duty without even recording any specific finding that the constructions were made prior to the execution of the sale deed. It is not the case of the respondents that the land in question was undervalued. An inspection was got done after 10 months of the execution of the sale deed. It is also not the case of the respondents that the constructions found on the date of inspection could not have been made within the period which was after the execution of the sale deed and till the date of the inspection. For imposing liability for payment of additional stamp duty, it would be the duty of the respondents to categorically show that there was some concealment made by the petitioner at the time of execution of the sale deed. On mere presumption that constructions existing after nearly a year must have been existing at the time of execution of the sale deed, stamp duty cannot be imposed after valuing the constructions without giving a categorical and specific finding that at the time of execution of the sale deed, such constructions had existed. It is settled law that market value for the purpose of determining the stamp duty has to be determined with reference to the date on which the document is executed and not on the basis of any improvements made on it thereafter. The sub-registrar or the authorities concerned should have verified the same prior to registration of the sale deed or immediately thereafter, but imposing liability for payment of additional stamp duty on the basis of a report submitted after nearly an year of the execution of the sale deed, during which period admittedly such constructions could have been made, would not be justified. As such, the orders impugned in this writ petition are based on no sufficient evidence to show that there is any concealment of any material fact on the part of the petitioner, or that the petitioner had purchased the plot with constructions. Learned counsel for the appellants argued his case and submissions were made by him. We may make it clear at the outset that none of the appellants belonged to the category of either SC or ST or ex-servicemen, and their claim is also not against these categories. Hence, we consider it unnecessary to consider the validity of selection of the candidates made in these two categories. In other words, we confine our consideration to the validity of selection of the candidates made in the general category. Mainly, the submissions made on behalf of the appellants were that after declaration of the result of the written examination on 1/4/1998, standard could not have been lowered for making other 40 candidates eligible for the purpose of interview. Criteria could not have been framed after declaration of result of the written examination. Maximum 21 candidates could have been called for interview in the ratio of 1:3 in the general category on the basis of the merit of the written examination, whereas out of 78 candidates whose result was declared on 1/4/1998, more than 60 candidates from the general category, learned additional solicitor general and learned senior counsel for the respondents at the outset submitted that they have preliminary objection for the very entertaining of these appeals, and considering the contentions advanced on behalf of the appellants on merit having regard to their conduct. According to them, the appellants made deliberate misrepresentation with regard to the allocation of marks, stating that 150 marks were for the written test and 100 marks for interview. Further, malafides were attributed to authorities on the basis of the relation and political influence which they gave it up before the High Court, but again reiterated in the SLP. According to the learned counsel, these two grounds are good enough to dismiss the appeals by revoking leave granted without examining them on merits. Although we find justification in these submissions, but having heard the parties at length, we consider these appeals on the merits of the contentions as well. On behalf of the respondents, further submissions were made explaining the criteria fixed, in what circumstances more number of candidates were called for interview, and how the selection made was fair and proper. According to them, mere calling more number of candidates for interview did not vitiate the selection made having regard to the facts and circumstances of the case. At any rate, the appellants being lower in merit, even otherwise, could not get any benefit. According to the learned counsel for the respondents, the impugned judgment of the High Court is perfectly valid and justified. They also submitted that pursuant to the selection made, the selected non-official respondents have been continuing in service since May 1998, that is, they are continuing in service for about 5 years by now, and as such, these are not the fit cases for exercise of jurisdiction under Article 136 of the Constitution of India to interfere with the impugned judgment and order.